Hi, I'm attorney Bill Bronchick, and in this video I'd like to explore with you the basics of the land trust. We'll start with what is a land trust and what do we use it for and what do we not use it for. A land trust is a basic, simple, revocable living trust that is used specifically to hold title to one piece of real estate. That is, one trust per property. It is simple, revocable, similar to an estate planning living trust, but specifically used and tailored for the use of holding title to real estate. Now, why would we use such a thing? Well, the first thing is privacy. If you don't want your tenants to know who you are and who the real landlord is, if you have an LLC, for example, they can go on the Secretary of State and look up information that's tied to you, whereas a land trust, there's no place publicly to look it up. Another reason you might want to use it is to protect yourself from any claims against the property for property taxes, for HOA liens, and for other claims against the property itself. Now, in terms of liability, it won't protect you from liability as the owner of the trust, and we'll get to who the owner of the trust is in just a moment. But it'll protect you from contractual things like unpaid water, sewer, HOA, and things of that nature. Also, it'll protect you from contractual claims, such as the signing of a warranty deed that ends up having a claim against it, such as an undisclosed lien or some claim that you didn't know about that later comes back to bite you. A land trust will protect you in most cases from those types of things. So there's lots of benefits to using a land trust for holding title to real estate. Now let's step back and look at what a trust is. A trust is a contract. It's not an entity like a corporation or an LLC. So it's not filed with the state as a living, breathing entity onto itself. It is a contract between the parties. And the parties to the contract are the trustee, who's in charge of the trust, the grantor, who's the creator of the trust, and the beneficiary, who is the beneficial owner of the trust. Now, when we create a land trust, usually the grantor and beneficiary are the same party, hence what we call a self-created or self-settled trust. So there's really only two parties, the grantor, beneficiary, and the trustee, who should be a party who has a different last name than you, because we're going to use the trustee's name on title to the property, not the beneficiary's name. So the trustee should not be someone who is obviously one of your relatives, someone with the same last name. Ideally, it would be someone who lives out of state, out of the jurisdiction where the property is, and ideally at a P.O. box. Now, compare that to, let's say, a corporation or an LLC, which has to have a registered agent in the state where the property sits and a physical address so you could serve them with a lawsuit, whereas a trustee, as an individual, could be at a P.O. box and can be out of state, even out of the country, and you can get documents signed by them by Federal Express or email, but you can't serve someone physically in a lawsuit. So the harder you make it on someone to poke around and get information, the more likely they're just going to go away and leave you alone, and hence that gives you the privacy that you need. The parties, the trustee and the grantor beneficiary, are going to sign a trust agreement, which creates the trust. So it's not filed with the state like an LLC. The trust agreement rather creates the trust. Now, a land trust is what is known as a simple, living, revocable trust. Revocable means you can change it, you can terminate it, you can take it back. Nothing is permanent. It's living in that you create it while you're alive, but it's not the same as the living revocable trust you may have done for estate planning for your family, a family trust. Typically in a family trust, Bill Bronchick would be the Bill Bronchick Living Trust, which doesn't give any anonymity or privacy. Whereas a land trust would have a simple name, would be named usually after the address of the property. So 123 Main Street Trust. Something very generic, doesn't point to you, it points to the property, care of the trustee at a P.O. box out of state. And you can see how that it's very beneficial to you in terms of privacy, in terms of difficulty for people poking around to figure out, let's say you have a code violation, and in some jurisdictions, if you have more than let's say 2 or 3 violations on that property within a certain time period, you have to go to court and you have to answer to a judge, where if it's owned, the property's owned in a trust, and every property you own is in a different trust, it's hard to get a lot of violations against you because they're different ownerships and they're private and they're out-of-state trustees, so it's hard to track them down. So it's very beneficial to you as the property owner. Now, the trust itself has a beneficiary, and that beneficiary can be you, or it could be an LLC or a corporation, etc. So, in terms of people asking me all the time, should I use an LLC or should I use a land trust? Well, it's not an either or. You can use both. So you can make the grantor beneficiary of the trust an LLC for liability protection as a layer, and then the trustee sits on top as the anonymity layer. So you really get the best of both worlds. One of the great things about a living trust, especially when it's living and revocable, the land trust is it doesn't have a tax ID number or file a separate tax return. The beneficiary, for all intents and purposes, is the taxpayer. So if you had it in an LLC and you transferred it to a land trust with that same LLC as beneficiary, then you would continue reporting it for ownership purposes and tax purposes as the LLC owning the property, but the leases would be in the name of the trust, and what people see on public record down in the county is the trust, care of a trustee at a P.O. box out of state, no public record to look up, no way to find out who the beneficiaries are. You could see how powerful that is. Now, setting up the trust, we said we set it up with a trust agreement. You have to change ownership of the property from the current owner. So if you're buying it, it goes from seller to trust. If you already own it in your own name, for example, you would just transfer it by deed and record a deed to the trust name. And then the beneficiary could be you or a corporation or an LLC and so forth. So this is the basic mechanics of a land trust, and we want to do is have a separate trust for each property. Now you're probably wondering, is there a cost involved? And not really. It's not a significant cost. The setting up of the trust, the creating of the land trust is the only real cost. There's no annual filing fees to a state. There's no tax returns to worry about. And the trust itself doesn't maintain a bank account. The money would be collected directly by the beneficiary or from a property management company that you either hire or one that you set up to manage your trust properties. This is Bill Bronchick. I hope you've enjoyed the basics of the land trust and all the benefits there are for you as a property owner.